Well, hello again, YouTube. It's Obama, by the way. Elena Kagan was nominated in 2010 by Obama. Don't ever cut me off again, YouTube, or I'll slap you in the face. Anyway, back to the text. The Senate vote in 2010 on Elena Kagan, who was nominated by President Obama, was closer even though the Senate hearings went smoothly. Although Kagan was confirmed by a 63 to 37 vote, most GOP senators voted against her, expressing a view held by many of these Republicans. Orrin Hatch of Utah said she lacked an appropriate judicial philosophy, which was his way of saying that some of her decisions would be at odds with his view of how the court should decide particular issues. Drink. Lovely. The President typically delegates to the Deputy Attorney General the task of identifying. Oh, by the way, I forgot to read you the title in my high-pitched voice. And I've got to get closer to you so you can hear me better when I'm shouting into the microphone. The title is Lower Court Appointees. I always want to say corn. The President typically delegates the Deputy Attorney General the task of identifying potential nominees for lower court judgeships, a process that includes seeking recommendations from U.S. senators of the President's party, and sometimes House members as well. Senatorial courtesy, a tradition that dates back to the 1840s, holds that a senator from the state in which a vacancy has arisen should be consulted on the choice of the nominee, if the senator is of the same party as the President. If not consulted, the senator can request that a confirmation be denied. Other senators usually grant the request as a courtesy to their colleague. Although presidents are not as personally involved in selecting lower court nominees as in naming potential Supreme Court justices, lower court appointments are collectively significant. A president who has served 2 terms can shape the federal judiciary for years to come. By the time he had left office, George W. Bush had appointed more than a third of the seated federal judges. Bill Clinton appointed a similar number during his 2 terms. Presidents typically select members of their own party for lower court judgeships. More than 90% of recent districts' appeals court nominees have been members of the president's political party. This fact does not mean that federal judges engage in blatant partisanship while on the bench. They are officers of a separate branch of government and prize their judicial independence. All Republican appointees do not vote the same way on cases, nor do all Democratic appointees. Nevertheless, partisanship influences judicial decisions. A study of the voting records of appellate court judges, for example, found that Democratic appointees were more likely than Republican appointees to side with parties who claim the government has violated their civil liberties. Personal background of judicial appointees. In recent years, increasing numbers of federal justices and judges have had prior judicial experience on the assumption that such individuals are best qualified for appointment to the federal branch. Elective office, particularly a seat in the U.S. Senate, was once a common route to the Supreme Court, but recent appointees, with the exception of Elena Kagan, who was Solicitor General, have come from the appellate courts. See Table 14-1, even though you can't because I'm reading it to you. White males are overrepresented on the federal bench, just as they dominate in Congress at the top levels of the executive branch. However, the number of women and minority group members appointed to federal judgeships has increased significantly in recent decades. The number of appointees has varied according to which party controls the presidency. Women and minority group members are key constituencies of the Democratic Party, and Democratic presidents have appointed more judges from these groups than have Republican presidents. Of President Bill Clinton's appointees, for example, roughly 30% were women, and 25% were members of racial or ethnic minority groups, compared with the 20% in each of these categories for George W. Bush. The Supreme Court has a degree of diversity. Of the 9 current justices, 3 are women: Ruth Bader Ginsburg, Sonia Sotomayor, and Elena Kagan, and 2 are minority group members, Clarence Thomas and Sotomayor. The historical pattern is more one-sided. Until 1916, when Louis D. Brandeis was appointed by the court, No Jewish justice has ever served. Prior to the 20th century, only one Catholic, Roger Taney, had served on the court. 6 of the current justices are Catholic, and 3 are Jewish, marking the first time the court has been without a Protestant member. Thurgood Marshall in 1967 was the first black justice, and Sandra Day O'Connor in 1981 was the first woman justice. Antonia Scalia in 1986 was the court's first justice of Italian descent. Sotomayor, who was appointed in 2009, is the first Hispanic justice. No person of Asian descent has been appointed to the Supreme Court. The nature of judicial decision-making. Unlike the president or members of Congress, federal judges make their decisions within the context of a legal system. Yet they are also political officials. They constitute one of the 3 co-equal branches of national government. As a result, their decisions, though rooted in law, also have a political component. Legal influences on judicial decisions. Article 3 of the Constitution bars a federal court from issuing a decision except in response to a case presented to it. This restriction is a substantial one. For one thing, it limits judges to issues that arise from actual legal disputes. As federal judge David Basilone noted, a judge can't wake up one morning and simply decide to give a helpful little push to a school system, a mental hospital, or a local housing agency. The fact of a particular case also limits judicial action. The facts of a case are relevant circumstances of legal dispute or offense. In the case of a person accused of murder, for example, key facts would include evidence about the crime and whether the rights of the accused had been upheld by the police. A judge must treat a murder case as a murder case, applying to it the laws that define murder and the penalties for it. A murder case cannot be used as an occasion for a judge to pronounce judgment on free speech rights or campaign finance laws. Judicial decisions are also restricted in their breadth. Technically, a court ruling is binding only on the parties involved. Its broader impact depends on the willingness of others to accept it. If a court were to decide, for example, that a school was bound by law to spend more on programs for the learning disabled, the ruling would extend to other schools in the same situation, only if those schools voluntarily complied or were forced by subsequent court action to do so. By comparison, if Congress were to pass legislation granting funds to schools for programs for the learning disabled, all eligible schools would receive funding. The major constraint on the courts is the law itself. I just lost my place. Although a president or Congress can make almost any decision that is politically acceptable, the judiciary must work within the confines of the law. When asked by a friend to do Justice Oliver Wendell Holmes, Jr. said he was bound to follow the law rather than his personal desires. The judiciary works within the context of 3 main sources of law: the Constitution, legislative statutes, and legal precedents. The Constitution of the United States is the nation's highest law, and the judges and justices are sworn to uphold it. When a case raises a constitutional issue, a court has the duty to apply the Constitution to it. For example, the Constitution prohibits the states from printing their own currency. If a state decided that it would do so anyway, a federal judge would be obligated to rule against the practice. The large majority of cases that arise in courts involve issues of statutory and administrative law rather than constitutional law. Statutory law is legislative, statute law. Administrative law is based on statutory law, but is set by government agencies rather than by the legislators. Administrative law consists of the rules, regulations, and judgments the agencies make in the process of implementing and enforcing statutory law. All federal courts are bound by federal statutory and administrative laws, as well as by treaties, and judges must work within the confines of these laws. A company that is charged with violating an air pollution law, for example, will be judged within the context of that law, what it permits and what it prohibits, and what penalties apply if the company is found to have broken the law. When hearing such a case, a judge will typically try to determine whether the meaning of the statute or regulation can be determined by common sense, the plain meaning rule. The question was for judge is what the law or regulation was intended to safeguard, such as clean air. In most cases, the law or regulation is clear enough that when the facts of the case are determined, the decision is fairly straightforward. The U.S. legal system developed from the English common law tradition, which includes the principles that a court's decision on a case should be consistent with previous judicial rulings. This principle, known as precedent, reflects the philosophy of state decisis, Latin for to stand by things that have been decided. Precedent holds that the principles of law, once established, should be applied in subsequent similar cases. Judges and justices often cite past rulings as justification for their decisions in the cases before them. Deference to precedent gives predictability to the application of law. Government has an obligation to make clear that its laws are and how are they to be applied. If courts routinely ignored how similar cases have been decided in the past, they would create confusion and uncertainty about what is lawful and what is not. A business firm that is seeking to comply with environmental protection laws, for example, can develop company policies that will keep the company safe within the laws if court decisions in this area are consistent. If court decisions are routinely ignored, precedent, a firm could unintentionally engage in an activity that a court might conclude was unlawful. A very sticky business this appears to be. Let's try different actions. Political influence on judicial decisions. Adherence to the laws and the judging of cases in what gives substance to claims that the United States is governed by rule of law. If the judges were to ignore or downplay their obligation to uphold the law, the public's respect for the law and willingness to comply with it would diminish accordingly. Nevertheless, the law is not always a precise guide to judicial decision, with the result that judges often have some leeway in their rulings. The Constitution, for example, is a sparsely worded document and must be adapted to new and changing situations. The judiciary also has no choice at times but to impose meaning on statutory law. Statutes are typically more detailed in their provisions than is the Constitution, but Congress cannot always anticipate the specific applications of a legislative act, and often defines statutory provisions in general terms. The judiciary is then required to determine what the language means in context of a specific case. Precedent is even less precise as the guide to decisions, that is, specific to particular cases. A new case may differ in important ways from its closest precedent, or rest at the intersection of competing precedents. In such instances, a judge must determine which precedent, if any, applies to the case at hand. The Supreme Court's rulings in Fargar v. the City of Boca Raton, 1998, involving sexual harassment in the workplace, illustrates the ambiguity that can exist in the law. The courts developed its rulings in the context of the anti-discrimination provisions of the Civil Rights Act of 1964. However, the act itself contains no description of, or even reference to, job-related sexual harassment. Yet, the act does prohibit workplace discrimination, and the court was unwilling to dismiss sexual harassment as a relevant form of job-related discrimination. In this sense, the court was making law. It was deciding how legislation enacted by Congress applied to behavior of the Congress and not specifically addressed when it wrote the legislation. In the end, the court decided that the sexual harassment on the job is among the types of job-related discrimination prohibited by the Civil Rights Act. Political influences affect how judges decide cases in which they have leeway. These influences come from both inside and outside the judicial systems. Inside the court, judges' political beliefs. Although the judiciary symbolizes John Adams' description of the U.S. political system as a government of laws and not of men, court rulings are not simply an extension of laws. They are also influenced by the political beliefs of men and women who sit on the federal bench. Change in the Supreme Court's membership, for example, can bring about a change in its position. Samuel Alito's appointment to the court in 2006 produced that kind of change. Although the justice he replaced, Sandra Day O'Connor, usually voted with the court's four most conservative judges, she sometimes switched sides, voting with the court's four most liberal justices. She cast the deciding vote, for example, in the 2000 Nebraska case that upheld the use of partial birth abortion when the mother's life is endangered. In contrast, Alito cast the deciding vote in 2007 decision to uphold a congressional ban on the use of partial birth abortion. Alito's decision in this case, and the others, prompted observers to say that the Supreme Court had swung right. Even one of the Supreme Court's justices admitted as such. "It is not often in law," wrote Justice Stephen Breyer, "that so few here so quickly change so much." Studies by Jeffrey Segal and Harold Spaeth show that justices tend to vote in line with their political attitudes. Segal and Spaeth examined thousands of non-unanimous court decisions, looked at the extent to which each justice voted on the same side of the opposite decision from the other justices. Clear patterns emerge, such as the tendencies of Antonia Scalia and Clarence Thomas, who are Republican appointees, to vote the same way and opposite